Assalamualaikum. Today our group will present the case related to vicarious liability. So what is vicarious liability? Vicarious liability describes a situation in which A is responsible to C for harm or damage sustained by C because of B's negligence or another type of tort. A further need not have committed any wrongdoing and need not have owed C a duty of care. The relationship between A and B and how the tort committed by B is related to this relationship is the most crucial requirement for holding A accountable. This kind of relationship typically exists between a principal and his agent as well as between master and servant, employer and also employee. There are three requirements which are wrongful or tortious act, special relationship, and the tort must occur within the course of employment. The first requirement is a wrongful or tortious act. First and foremost, the court will determine whether a tort has been committed. Each requirement of the specific tort must be met. The nature of the relationship between the defendant and the tortfeasor will be looked at after a tort has been established. The second requirement is special relationship. An employer and an employee are said to have a special relationship because there must be a connection between the defendant and the tortfeasor. When a wrongdoing occurs on the defendant property but the wrongdoer is not an employee, the employer is not held vicariously liable for the wrongdoing. The employer and employee relationship is the only special relationship that is being discussed here. And the last requirement is the tort must occur within the course of employment. Only torts committed by an employee while on the job bring the employer vicariously liable. When an employee acts in a way that is not authorized by the employer, when they carry out an authorized task in an improper manner, or when they carry out an act that is closely related to the task for which they were hired, the behavior is said to be in the course of their employment. The fact of each case determine whether an act is what ought to be done or what should be done while performing the job. So, next is name of case law. The case is between Fanuc Sendang Berhad and ADENLAND Sendang Berhad and ANA. A plaintiff for this case is Fanuc Sendang Berhad and there are two defendants. The first defendant is ADENLAND Sendang Berhad and ANA. Meanwhile, the first defendant had appointed the second defendant, which is Prestasi Infrabina Sendang Berhad, to perform the excavation work.
Next, I will continue with identification of case. Prestasi Infrabina SDN BHD had been chosen by ADENLAND Cheras SDN BHD to perform excavation work. Simon Lim, a representative for the second respondent, oversaw the construction while Andy, a clerk of works for the first respondent's consulting engineers Perunding Intas, served as the first respondent's representative for the purpose of overseeing the condition imposed by Majlis Perbandaran Kajang. The appellant learned that the second respondent had trespassed onto the appellant's land while performing these works. It should be noted that the appellant intended to construct hilltop bungalows on the above said property, but the second respondent's trespass reduced the height of the appellant's land. As a result, the appellant filed a lawsuit against the respondents for negligence and trespass. Despite finding that the second respondent was the first respondent's agent, the High Court judge allowed the claim against the second respondent but dismissed the claim against the first respondent. The HCJ further ruled that there was no proof the first respondent knew the second respondent had trespassed on the appellant's property. In this appeal, the appellant claimed that the first respondent and the second respondent should share responsibility for the trespass that was committed by the latter. Further, the appellant was dissatisfied with the HCJ's decision in rejecting first, the appellant's claims which represents the value of the earth taken from the appellant's land. Secondly, the reinstatement fee for which the first respondent claimed that the PW7's design was tentative and not final because of errors in the numbers of boreholes, pile size, lack of a soil test and etc. And lastly, punitive and severe damages, whether the first respondent should be held jointly and severally liable for trespass as the second respondent's principle was at the center of the current appeal. I will proceed with facts of the law case. On March 6, 2017, the plaintiff filed against D1 and D2 citing negligence and trespass as causes of action. D2 didn't argue against the action. D2 did not reply to this appeal either as the second respondent in this appeal. The plaintiff's claim against D2 was denied by the judge in a decision dated June 19, 2019 along with 80,000 in costs. In essence, the plaintiff is resentful with the High Court's ruling absolving D1 of responsibility for trespass. The plaintiff contends that D1 and D2 should be held jointly and severally liable for the trespass committed by the latter. The plaintiff's land, which was on a higher elevation, was not far from the project land. A road reserve and an access road known as Jalan Kemacahaya, also known as the access road, separate the plaintiff's land from the project land. D1 had previously spoken with the plaintiff to gain their approval for the plaintiff's land's height to be trimmed. Therefore, if the plaintiff's land's height was decreased, a high retaining wall wouldn't be necessary. However, the plaintiff did not give her permission. D2 removed a significant amount of earth while performing the work as stated in the letter of award. It also encroached upon and cut into the plaintiff's land. The cutting and excavation caused a significant reduction inside the height of the plaintiff's land because of the encroachment. To find a solution, D1 and the plaintiff engaged in negotiations, but eventually, there was no agreement and the negotiation process was abandoned. The plaintiff's land was left in the state it was in after the trespass, which included being significantly reduced in height from what it was prior to the trespass. D1 did nothing to correct the situation. As previously mentioned, D1 planned to build a retaining wall along the road reserve which was below and close to the plaintiff's land and straighten the access road. It is commonly accepted that D1 would need to build a tall retaining wall if the height of the plaintiff's land was kept at its original level. Perunding PLL's SDN BHD, D1's engineering consultants requested MPK's approval of the infrastructure plan. D1 suggested to MPK building a retaining wall along the road reserve, which is a few meters away from the plaintiff's land's boundary, to stop erosion and landslides following from the plaintiff's land. On January 20, MPK gave the go-ahead for D1's plan to build a reinforced concrete retaining wall and related earthwork. The MPK conditionally approved the infrastructure subject to several terms and conditions.
Assalamualaikum, my name is Muhammad Natim Najhan bin Muhammad Nazri, and in this part I will explain about decision by courts. First, there is no proof that because that AnorDATED gave D2 the orders to trespass the property of the appellant, the judge in the High Court excused the company from their liability. Next, the plaintiff failed to grant AnorDATED authorization to trim the plaintiff's land. Therefore, there is no need for the retaining wall. The project award letter from the AnorDATED to Prestasi Infra simply instruct the company to determine the boundaries before the beginning of the project and did not mention building of retaining wall. Therefore, D2 activity may have no reduced to the plaintiff's land, which has often the plaintiff. The plaintiff claim for removed earths, resistant cause and additional and aggravating damage was likewise rejected by High Court, even though they intend to construct the retaining wall beneath or near the plaintiff's land boundaries. AnorDATED did not want to be held accountable. It is generally acknowledged if the height of the plaintiff's land is maintained at the previous level, AnorDATED would like to construct a sustainable retaining wall. Therefore, any reduction in the height of the plaintiff's land would be required to build a lower retaining wall, saving AnorDATED money in the long term. Furthermore, according to the AnorDATED, D2 is an independent contractor, is not bound by the master of the sovereign principle. The letter of award that states the work must be completed and certified by AnorDATED consulting engineer which indicated by the prestasi infra is a sovereign rather than the independent contractor, as stated in the hearing, because they were being supervised and monitored by other parties. However, the appeal court found that AnorDATED is liable to prestasi infra. Lastly, the damage with 5% interest per annum, value of earth removed, resistant cost. The court's order that the judgment be entered against AnorDATED and prestasi infra jointly and several for special exemplary damage, and the order of the cost that was awarded by the High Court is set aside and replaced with an order of the cost to put the plaintiff in amount of 50,000 ringgit.
Assalamualaikum, my name is Muhammad Akil Zafurullah bin Rusli. So for my part, I will conclude this whole case law. For the vicarious liability that mentioned in this case, vicarious liability is when the employer is liable for the employee wrongdoing that bring damages or losses to the other party, and the other party can sue between employer, or even both. Usually, the suit is better is to sue the employer because of in every construction project, the employer will have the insurance that cover contractor or risk and also the compensation. So in order to the suer to sue the employer, they need to provide argument that the employer is liable to the act of his employee. The agreement need to contain there is relationship between the employer and the employee that shows the employer had obligation to bear the consequences done by his employee. So back to this case, prestasi infra had been chosen by the ADENLAND to perform the excavation work, and prestasi infra trespass onto the appellant land and reduce the height of the appellant land. So before this, in the High Court, the judge has cleared the ADENLAND from the responsibility because there is no proof that ADENLAND is instruct prestasi infra to trespass the appellant's land. However, the appellant claimed that ADENLAND should liable with the prestasi infra, the act of trespass and the negligence that been occurred by the prestasi infra. It is because the appellant did not give the permission to the ADENLAND to trim the land. So, ADENLAND claimed that if the plaintiff give permission, there is no retaining wall need to be built. But in the letter of award of the project that are issued by ADENLAND to prestasi infra, there is not covered about the retaining wall construction, but only told to establish the boundary to perform the works. So the prestasi infra carry out the work that can cause the reduction of the plaintiff land that made the plaintiff outrage. So High Court also denied that the plaintiff claim, which is the removed earth and reinstatement cost and explanatory and aggraving damages. ADENLAND not want to help the liable, even they plan to build the retaining wall below and close to the plaintiff boundary. So it is common accepted that ADENLAND would need to build the retaining wall in the height of the plaintiff land, so it keep at its original level. Therefore, any decrease of its height of the plaintiff land would be necessitate that the construction of the smaller retaining wall, which would ultimately result in the cost saving for ADENLAND. So, ADENLAND also claimed that prestasi infra is independent contractor and not touched between the master and servant principle. And however, the appeal court find it otherwise. The ADENLAND is liable for the prestasi infra because in the letter of award, there is mentioned that the work must be satisfaction of ADENLAND consulting engineer, which shows that Prestasi Infra is a servant, not the independent contractor, as mentioned in the hearing. Because the work will be supervised and monitored by the consulting engineer from the ADENLAND. Lastly, the court ordered the judgment to be entered jointly, severally against ADENLAND and Prestasi Infra for special damages with 5% interest per annum, the value of earth removed, reinstatement costs, explanatory damages, and the order of cost that awarded in the High Court is set aside and will be substituted with the order of cost to the plaintiff in the sum of 150,000. Okay, for what lesson that we can learn from this case, that we need to be responsible for the action that done by the person that we entrust the work. As we know, the vicarious liability using the master and servant concept, which is the employer will and need to help liable for the employee wrongdoing. In this case, ADENLAND don't want to help liable for Prestasi Infra wrongdoing because ADENLAND mentioned in the court that Prestasi Infra is a independent contractor that not linked with the ADENLAND. However, the letter of award mentioned that work done by the Prestasi Infra will be monitored and supervised by the ADENLAND engineer consultant. That shows there is connection and between ADENLAND and the Prestasi Infra. So, ADENLAND don't want to be free from the charges, which is doesn't want to be responsible for the Prestasi Infra wrongdoing. So next, we should not be selfish to maximize the profit that will bring losses or damages to others, because there will be consequences if we be greedy like ADENLAND. ADENLAND built a lower retaining wall to benefit himself, with supposedly to be 6-meter retaining wall. However, it only built 4.13 meter high retaining wall. In fact, it would be need 11 meter wall to prevent this from happen. But ADENLAND says it is uneconomical and expensive solution, so it will bring profit to the ADENLAND. But when this happen, it will bring more losses to ADENLAND. So lastly, we need to respect the other's decision for their property. As said in this case, plaintiff refused to let the defendant trim her land because the land will be used to build a hilltop bungalow in the future. But the work done by the Prestasi Infra is trespass the land and also bring damages to the land. So from this situation, we need to respect what the plaintiff or other people said about it's their own property. They have the right to do whatever they want. So if we don't respect the other decision, it will bring consequences in the future. So that's all from me. Thank you.